If at first you don't succeed, try again. That's supposed to be philosophically sound wisdom on the value of perseverance, generally good advice for good behavior. Except in the context of disregarding the Constitution and violating citizens' rights, then it's much more of a problem. And outside of California, there's probably no state more persevering in that cause than New York, fraudulently signaling to the world that it's somehow a harbor for liberty, while internally working to make everyone a dependent of the state. And I don't mean dependent just in the financial sense, though of course these politicians prefer that too. I mean it in the most fundamental sense, dependent for your very physical safety itself. If someone confronts you and threatens you and attacks you, well, just sit back and enjoy the beating as you patiently wait for the state of New York to show up and intervene, if they ever do at all. But that's really the point. This is a philosophy that says your life exists to serve the state, not the other way around, as the Declaration and the Constitution prescribe. And fundamentally, that's the philosophy that keeps pulling the state of New York's self-defense laws back into court. Recall back in June, somewhat in the shadow of the Dobbs decision overturning Roe v. Wade, was the Bruen decision. Clarence Thomas refocusing his laser eyes on New York's concealed carry laws. In New York, it was all but impossible to get a state permit to carry a gun in public, because the state made you prove what it called proper cause, as in some special need that you have beyond the general public. Even though the whole point of the Second Amendment is that right is already yours. It's everyone's, in fact. It's not some special award that you get when you sufficiently impress the state. And acknowledging that truth is why the Bruen decision is so important. The Second Amendment remains one of the more ignored pieces of the Bill of Rights, at least as far as the Supreme Court's interaction with it. Historically, they rarely touch it. And even though the language of the amendment couldn't be much clearer, the right of the people to keep and bear arms shall not be infringed, until recently, the Supreme Court had yet to affirm that meaning. It wasn't until 2008 and the DC versus Heller decision that the court said, yes, the Second Amendment protects an individual right to gun possession. In the 2010 McDonald versus Chicago decision, the court said, yes, that right extends to the states through the 14th Amendment's incorporation of the Second Amendment. And then this year, in the case of the New York State Rifle and Pistol Association versus Bruen, the court said, yes, the Second Amendment also protects an individual right to carry a gun in public places in general. Indeed, that's implied by the phrase keep and bear itself. To keep, as in to possess, or to store, or to own, and bear, as in to hold, or to be equipped with, or, yes, to carry. The court's reasoning is as simple as reading the text itself, with the only wrinkle being the application of the Second Amendment to the states. I do recognize there is an entire debate as to whether that's correct as a matter of law and philosophy, and as I've mentioned before, I'm actually very sympathetic to that argument. But for the sake of this video, I will assume that, like all of your other rights secured in the Bill of Rights, the protection of your Second Amendment rights is just as valid against your state as it is against the feds, since that is the legal status quo. We can assume that, but the state of New York certainly won't, and they didn't. That Bruen decision was released on June 23rd, and almost within a week, New York's legislature and governor replaced the bad old law with an even worse new one. They said, if we can't have a proper cause requirement for being impossibly selective with who gets a concealed carry permit and who doesn't, emphasis on doesn't, then fine. We'll just use a different standard. Now it's a good moral character requirement to be demonstrated through several more hurdles, not just a special need like last time. Now the state of New York will review your social media and consult with references you must provide, and call your family or domestic partners through contact information you also must provide. Plus, you'll need to complete 18 hours of state-approved and state-administered training and whatever other stuff the licensing officer deems reasonably necessary, even though the state's standard for Second Amendment reasonability was just invalidated as unreasonable, and even though this is just a statutory invitation to make it up as they go, in total defiance of a constitutional right, exactly what was just struck down in June, now revived and aggravated. And just in case they fail in restricting who can carry a gun again, well, the state of New York has added another component for good measure. They'll just control where people can carry guns. If they can't control the people, they'll just control the places. And so even if they do have to give you a concealed carry license eventually, that concealed carry license means next to nothing if everywhere is a state-ordered gun-free zone. That is the second piece of this new law, a miles-long list of places now declared quote-unquote sensitive locations on which all gun carrying is prohibited regardless of the carrier's licensure or not. It would take me an entire video's time just to read all of these places, but here are some highlights. Any place owned or controlled by government of any kind, state, local, or federal. Any healthcare facility, any religious facility of any faith, libraries, playgrounds, parks, zoos, daycare centers, schools, including preschools, homeless shelters, public transportation facilities or vehicles, polling places, even the sidewalk if the government says that's a restricted sidewalk. And most ironically, any gathering of individuals collectively expressing their constitutional rights to protest or assemble, but no exercising your other constitutional rights. Those don't count. And of course, they call it the Concealed Carry Improvement Act, but improvement is a term relative to your perspective. It may be an improvement if you're a New York tyrant, but it's certainly not an improvement in terms of bringing the old law into compliance with the Constitution. It's a double down on the same things that made the last one unconstitutional, just reimagined and rephrased. So if you repeat the same constitutional attacks, you will get the same legal challenge, and you'll probably get the same legal outcome. And that is exactly what's happening with this new law. It's been challenged in federal court by 7 New York men who wish to carry their guns for self-defense in public with the assistance of Gun Owners of America, a gun rights organization. In U.S. District Court for the Northern District of New York, Judge Glenn Sotheby is overseeing the case, and on Thursday blocked several provisions of the new law as unconstitutional pending review, using the analytical framework and reasoning that the Supreme Court's Bruen decision in June established. Of course, this judge is going to take a lot of heat from activists and New York politicians now, but the truth is, it's really out of his hands. As a lower court judge, he is bound by the precedent and the standards of the Supreme Court. All he did was apply the same standards to the same sort of infringements. And in fairness to this judge, he's trying to be specific and thoughtful about it. He could have just trashed the whole law. He didn't. Instead, he took just the parts that don't comply with the Supreme Court's standards and he put them on pause. The other piece of the Supreme Court's Bruen decision from the summer that's very important is the new test or evaluation method that courts are now supposed to use in analyzing a law's compliance with the Second Amendment. Prior to Bruen, lower courts would consider both the means and the ends of any gun law, weighing the burden on gun rights against the government's rationale or the perceived benefits of the law. But the Bruen decision scrapped that framework, with Thomas writing the new standard is a historical evaluation. For a gun law to survive Second Amendment scrutiny in the courts, he wrote, the government must demonstrate that the law or restriction is consistent with this nation's historical tradition of firearm regulation. And on that basis, the judge in this case carved up what has historical precedent in New York's new concealed carry law and what doesn't. The judge says that this good moral character standard overall must be altered to put the burden of proof on the state, not the concealed carry applicant, meaning the state has to show you are a danger, not that you have to show them that you're a good guy. This language alteration made to presume that all citizens are entitled to this right, not to presume that they have to earn it. And in terms of how they do that, well, this is where the scalpel comes out. Based on this historical analysis, some things are constitutionally fine, some things are not, and are now temporarily restrained, the judge says. Character references and state training are fine, the judge says, based on historical standards of witness testimony to support sworn statements and training requirements prior. But mandatory family and cohabitant contact information, social media review, in-person interview, in these requirements, the judge says the state failed to provide a historical standard or analog, and so these are now temporarily restrained. And the judge applied the same historical analysis to the long list of so-called sensitive locations as well. Some places, like government buildings, indeed do have a long history of prohibiting firearms. Others have no such history or even comparable history at all. So, for example, the judge says the classification of religious facilities as gun-free sensitive locations cannot stand unless the law gives an exception for those keeping the peace on site. The public transportation facility and vehicle restriction cannot stand because the history is actually the opposite in that case. Historically, laws allowed carrying firearms while traveling. The restriction on any sort of entertainment facility or places serving alcohol also cannot stand. They too lack a historical tradition, the judge says. The list goes on. And on and on and on. The point being that the state can't just call every place a sensitive location where carrying a gun is prohibited and still be square with the Second Amendment. What separates what can and cannot be a prohibited zone is a legal tradition of that prohibition. And so where the state of New York cannot demonstrate that legal tradition, that particular piece of the law is gone, or at least temporarily suspended from enforcement. And I understand this judge is just following what the Supreme Court is telling him, and that's the way he's supposed to operate, so I don't fault him for that necessarily, but I do find this analysis unsatisfying in that it has little to say about the other rights at stake as well. Indeed, the guys challenging this law brought the case on First and Fifth Amendment infringements too. And that is the understated piece of just how egregious this new law really is. It's not just an attack on your gun and self-defense rights. It's an attack on your speech and property rights, too. By restricting your speech as a qualification to access your gun rights, New York is making the exercise of one right dependent upon the infringement of another. You can only carry a gun to defend yourself if you're a good boy who says all the right things on Facebook, or if you just say nothing at all. But if you say the wrong thing, they will punish you, not just with the restriction of that right, but with the removal of another right altogether. And that same sort of infringement applies to property rights as well. Even if we do think it's wise to have tighter gun restrictions in some places over others, in the context of private property, whose decision is that to make? Whose property is it anyway? Is it the state's? Or is it the property owners? If I run a church or a daycare, for example, personally, I absolutely want armed security on my property. Now, in fairness to the law, it does make an exception for armed security guards that the state approves. But what if I want my neighbor who I trust to do it? Or what if I want my church protected by every neighbor in the congregation? It is our defense on our property. So what business is it of the state's to declare my property a restricted zone where no guns are allowed? And again, just like the social media review, this is the state holding one right hostage against the exercise of another. The state of New York says you will only be allowed your First Amendment rights to assemble and worship if you surrender your Second Amendment rights to their control. Now, of course, these are more tangential questions I'm sure this district court judge would rather not exceed his authority to evaluate, or even the necessity. Don't go any further than you need to, I get it. But given this case is so similar to the last one, its fate will likely also be the same, and so maybe we'll get some more Supreme Court analysis on these broader issues later. After this district court judge paused the enforcement of the select parts of the law, New York Attorney General Letitia James has now appealed, asking an appeals court to allow the law to remain in effect and enforcement while its constitutional challenge works its way through the court system. Gun Owners of America also says they plan to continue the fight, and so it's very possible that this law gets right back to the spot that prompted it, Clarence's place at First and Capitol. That is, if anyone still lives in New York to make that case still relevant when it arrives. At this pace, the rate of people fleeing the state may render that decision moot, as even PolitiFact's fact-checkers must acknowledge. And it's often tempting to view that as the wisest solution. I often do, after all. It's much easier to leave than it is to fight rabid tyranny every single day, or at least it is assuming that the rabid tyrants someday give up and start leaving you alone, assuming they don't follow you to wherever you go next to actually build a little prosperity away from them. But that's the problem with the rabid tyrant. By his very nature, he will come for you. That's exactly why the Second Amendment was written. So we can either protect it or we can learn its purpose the hard way. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Gab. That is at MLK Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.